and welcome to Facts or Frauds.
Yes, Your Honor, David, on behalf of the City of Taylor.
All right. And for the defense?
Good morning, Your Honor. Attorney Josh Hadley. I appointed counsel on behalf of the defendant, Mr. Eric Martin. Briefly, Your Honor, I'd like to make a record. We were before this court last week, and there was a motion, a pro se motion filed by Mr. Martin to have me replaced as counsel. I was never served a copy of that. Your court graciously did send a copy. I have had a chance to review it. Your Honor, I would just again state that if Mr. Martin and I have a fundamental disagreement as to trial strategy, pursuant to People v. Charles O. Williams, 386 Mich. 565, 1972, good cause exists for a substitution of counsel. If there's a difference of opinion between the defendant and the appointed counsel with regard to a fundamental trial tactic, as well as going to People v. Bass, 88 Mich. 793, 1979, good cause can also be found when there's obstruction of communication and breakdown. Now, my recollection, Your Honor, your basis last time in denying the motion was really how late in the game the motion was. It was going to be prejudicial, essentially, and disruptive of the judicial process.
That's correct.
If I recall correctly, one of the other concerns we addressed was the concept of Mr. Martin's belief, which I think we've now clarified, that I'm not restricting him from speaking in any way, shape, or form today.
Nope.
Very well. Your Honor, I would also like, I believe, again, I don't want to put words into this court's mouth. My understanding is my role today, as if Mr. Martin wants to advance the defense that he has selected, I'm here to aid him with the understanding of the Michigan court rules, the Michigan rules of evidence, and all federal and state applicable law.
That's correct.
Very good, Your Honor. Okay, because of that, again, I think I just, for Mr. Martin and myself and this court and the people to be on the same page, for these reasons, I will not be making an opening statement, or I will reserve an opportunity for a closing argument. And
I will say this, I'm going to go ahead and give the ground rules to Mr. Martin so that he understands. Mr. Martin, you are lead counsel. You are your own lead counsel, and you choose to be representing yourself. Is that correct?
Present myself, not to represent. I am myself, but
listen,
I'm not presenting myself.
I'm going to tell you this right now. I'm going to say it one time. I'm not going to sit here and split hairs on meanings of words. To represent oneself or present oneself means the same thing. You are speaking on your own behalf. Yes?
Right, yeah.
Right, very good. Both of them mean the same thing. So we're not going to play semantics because literally I'm a walking thesaurus. So I'm not going to do that. And I'm going to shut that down because you're just going to waste time. And I'm not here to stall and waste time. I'm here to make sure your due process and you have a fair trial. And as part of that fair trial, you're not going to try to disrupt the proceedings by either stalling, playing semantics with, well, it's present instead of represent. It literally has present in it. Represent just means to redo it again. That's all. And so every time you get up, you're just representing yourself again. You're representing is what it means. That's what represent.
I make up the semantics.
So anyway, so here's the thing. You're going to be the lead counsel, so you're going to do your opening statement, things like that. You're going to follow the court rules. You're going to follow the same rules of evidence that everybody else follows. Mr. Greco is not going to have any advantage over you. You're not going to have any advantage over him. If you have, you literally have a legal encyclopedia sitting next to you. Someone who is very confident in the laws and the court rules and the statutes and the rules of evidence. So if there's an objection or things like that, I will pause. So that if you think that there's an objection and you think that there is something like that, I'm also going to ask you, because you have someone who is so astute at trial practice, if your co-counsel, are you giving your co-counsel permission to say objection when he sees something objectionable that you don't recognize? Because I'm just going to say you don't have a Juris Doctorate, you haven't formally studied the rules of evidence in a formalized setting. You could have done so online or anywhere else by library or by book or whatever. I don't know that you have or haven't, but I don't want to presume. But I just want to know for the flow of things, because if someone says something, they're going to keep asking questions unless somebody jumps in with an objection. If you don't recognize the objection, but he does, are you giving him permission to assist you by saying, hold up, that was objectionable?
Yeah, as long as he's going by the law and not doing nothing that's gonna violate my rights.
Well, I just want to know, I mean, and I'm making sure that this is your protection. He's there for your protection. I'm asking this question because just from a flow of trial standpoint, somebody who knows what's going on would be, because I do it all the time, sometimes sitting here. Like someone will ask a question and I kind of like, I'm watching. And I would have said objection if I was the other side and they don't object. And I don't even know if they didn't pay attention or they didn't know, or I don't know. But I can't do that for you. I have somebody here who is very astute at that. Are you giving him the power? I know you want to speak for yourself, but this is the one situation where you have to respond like right now. You have to like block, you have to like do something. And if you don't recognize it, I want to make sure that you are giving him permission for him to do that. Is that okay?
I'm going to do it, but I also reserve my right to also make.
No, sure. I mean, and all I'm saying is I'm going to have him call the timeout. I'm going to have him till the timeout flag by saying objection. Then you two of you can talk about why it's an objection and then speak to the court. Because if obviously you didn't see it or recognize it, he did. So there's probably a reason why, because he's not just going to throw out the word objection for every little thing. You're also not going to throw out the word objection for every little thing. Because if you say, I'll give you three. If you come up with 3 frivolous objections in a row because you don't know the court rules, then I'm going to turn the case over to him because he knows how to do it. You understand what I'm saying? I got no problem with you and your closing argument, your opening argument. Sure. If you want to cross-examine a witness, sure. But it better be within the rules. It better be as to the elements. And it better be as to the case, not anything and some other tangent about anything else. It has to pertain to relevance, because every single piece of evidence, I'm just going to give you a quick update on the rules of evidence. The first rule, rule 401, is that all evidence must be relevant. So if it has nothing to do with the elements of driving on a revoked license, I don't want to hear it. If it's anything to do with bias, yes. You can go into bias because that is one of the things that you can bring up under Rule 403. But under Rule 403, there's also overly repetitive evidence. So if you're going to ask the same question 20 times, just in 20 different ways, you're going to get an objection, and I'm going to sustain that objection. You understand what I'm saying?
Comprehend.
Okay, very good. That's all. And I just want to make sure so that, because everybody who's here, who's going to be in the jury, they have a right to serve as jurors. And I'm not going to have them sit here for an extra hour just because you want to play semantics, because now you're violating their rights perhaps by doing that. But I want to make sure that you have full representation. I want to make sure you have full due process. I want to make sure you have access to an attorney. And again, I'm going to ask you, are you knowingly and voluntarily choosing to not take house counsel? You're going to represent yourself as lead counsel?
Again, like I said, before.
Just yes or no. I mean, are you representing yourself as lead counsel or knowingly and voluntarily?
I reserve my right to say what I want to say and help myself with the case, but it's also okay for him to, also want him to do his duty and offer me the effective.
So that's what I'm saying. Is I don't want to leave him in a position where he doesn't know exactly what his duty is. He's either lead counsel or he's just a helper who's just going to sit there. Unless you ask him a question, he's not going to do anything. That's why I'm trying to ascertain exactly what it is you want from him. Officer Rose, good morning, sir. I'm well. I'm always well.
Okay, well, first remember, Slaven, you said yourself, you said it was okay, Judge Slaven, you said it was okay that I say what I want to say, and you said it basically. So I don't see what the questions.
But the questions aren't supposed so much for you. The questions are basically because I want to define the parameters of what your co-counsel is going to be required to do. Because I'm not going to have a situation where you're like, well, he didn't say objection on this one time and he could have had an objection and now I'm going to sue him. Because you're asking me to appoint him sort of with one hand tied behind his back. He's either going to be able to do his job to the fullest extent and represent you as a zealous advocate that he is, or he's going to be an encyclopedia of legal knowledge sitting there only waiting for you to take the book off the shelf. I did create that one situation where you could let him carte blanche. If he thinks there's an objection, say objection, which will just basically be a timeout. Then you can group or powwow, whatever you want to call it, about what that objection would be. And then we'll proceed and I'll make my ruling on it. But other than that, he's not going to jump in chime in, any of that? Is that what because you're running the show on the representation, correct?
Well, yes, but I was gonna say,
There's no.
I don't want to give up my right to effective assistance of counsel.
Right,
Well,
that's what I'm saying, you're either gonna accept it or you're waiving it, there's no half waiving it.
Um,
You understand what I'm saying? And I'm just making sure what it is, because I don't mind whichever way you choose.
Based on what he just told me, I should say lead counsel based on, not just because what he told me, but.
So based on, well, first
But
of
like I
all,
said, I want to do this job, I want to say what I'm
hold
saying.
on, because I don't want you to say, because I don't want to hear whatever private conversation you had between the two of you. Because I know you just said the words based on what he just said. I didn't want you to say whatever, because that's private. And no one can make anybody testify what you two talk about. That's privileged. If you say, listen, if you say to the court, or if you say to anybody, anything he said, it removes and washes away all privilege to it. Okay, so I'm just letting you know that, so you understand. So any conversations you have with counsel, even though he's not technically counsel, but he's your assistant counsel, any conversations you have are privileged. So unless you say, well, he just told me this, well, now you just threw it. So I'm just trying to lay these ground rules so that we don't run into this during the trial anytime. So that you understand and agree. And I just want to make sure that you are knowingly and voluntarily choosing to represent yourself, knowing that I would have given you full access to an attorney. You're choosing not to take that access and you want to represent yourself. That's correct?
I'm choosing to present myself, but also I'm not waiving my right to be helped by him because I still have the right to do it. So I'll still.
Okay. So if he sees any objections, he can do objections, but other than that, you'll just stop and ask.
And like I said, then
Okay.
we can't. I ain't predicting the
Just
future,
making
so
sure.
I don't know what's going to happen. You don't. But as long as he don't say something violates my rights, if he does, then I'm going to let that be known. I'm object to him, whatever.
Well, see, now we're right back to. All right. So you know what? I'll just play it by ear. And if I think that you're doing anything at all that's contemptuous or just trying to stall on this, then I'll make my rulings at that point. But
I feel very comfortable with the understanding of the speaking objections, just so I'm on the same page. Everything else I will serve in a co-counsel role.
Yep.
Until directed otherwise.
Yep.
Very good, sir. Thank you.
Very good. All right. So now, as to the motion. Doesn't have a motion. Oh, I just. So if they can't hear, I don't know if they can't hear. I don't know. It's not my problem. It's for the public comment. I'm not sure what's going on. All right, so I see you filed a motion this morning. This motion is a motion and demand to dismiss or discharge this case based on equal protection clause violations. And I have read through your motion. And did you give your co-counsel the opportunity to read the motion? Just in case if he asks you any questions, or if you ask him any questions.
Your Honor, I have had an opportunity to review all of the pro se motions that have been filed in this matter. So yes,
including the one this morning.
We had a chance to review it together.
Okay.
Yes, sir.
Right. Just want to make sure in case you need to assist in that way.
I guess I'll just add, I have nothing to add.
Sure. All right, so this is your motion, Mr. Martin.
Yep.
And basically it states that you think that there's a conspiracy between the police department, Officer Borg, Mr. Greco, and myself to prosecute you and keep you from getting your moped back. So basically
not just it. It's not completely totally current. So okay, so the prosecutor called herself supposedly prosecuting me here on this case when I have sought to prosecute Anthony Borg for stealing my moped, which is larceny, without my consent in violation of Declaration of Independence of 1776, along with my due process rights of the Michigan Federal Constitution. Okay, he had it towed immediately. And like I said, I filed actually state criminal charges myself with this court. They haven't been acted on. Greco here has not made no effort to prosecute it. And basically, like I said, so that violates my equal protection right. You know, if I'm being prosecuted, I have the right to prosecute when crimes being committed against me. But that hasn't been respected in violation of my crime victims' right of the Michigan Constitution, in addition to the due process. So yeah, like I said, so it violates equal protection clause violation, not allowing me to prosecute also for the crimes committed against me. Therefore, the case should be dismissed based on that.
And Mr. Greco?
Yes, very briefly, Your Honor, I just had an opportunity to look at it, and this motion has no basis in fact, law, or logic. Mr. Martin is being prosecuted validly because he was operating a moped on the road with a revoked license and or no valid license. The moped was taken by area towing at the time because it cannot be left side of the road and not left in his custody when he is refusing to acknowledge that he is supposed to have a license to operate a moped on the road. There is no basis to charge anyone else criminally or conspiratorially in this matter. So it should be denied.
Can I respond to that?
I'm sure.
Okay, well, first of all, state statutes cannot violate the Constitution. As we know, and the Constitution clearly says that property is not to be deprived before a due process of law, before a hearing. That was, as you just admitted, it was taken by area towed immediately. Without before a hearing, without any due process of law. It did violate due process. And besides that, based on my right to travel, my right to own my private property, I wasn't supposed to take it anyways. So the state, even just a state statute that seems to allow it, it's an unconstitutional state statute, and that doesn't override the Constitution. Again, the Constitution says private property is not to be deprived.
All right. So based on all the testimony that I just heard and reasoning, plus after having read through the motion, I am going to deny your motion. There is no violation of equal protection under Michigan Compiled Law 257.252A. Which is the abandoned vehicle statute. Anytime that there is a situation where a vehicle has to be abandoned, obviously the driver of the vehicle was arrested for not having a driver's license. That vehicle can't just sit there on the side of the road, because why? Well, that's the city's job to protect that, and it also becomes evidence of of what was taking place. So that has to be impounded pursuant to the abandoned vehicle statute. Additionally, the due process that you say you are not going to seek, you actually will seek, because it's built into Michigan Compiled Law 257.904B, which states that when a person is convicted of an offense that's punishable by that section, the local ordinance, basically for operating a motor vehicle while their license is either suspended, revoked, or denied, the court shall order that the motor vehicle, if it is owned in whole or in part by that person, and the court shall order that the vehicle be impounded for not less than a period that the court orders, but not more than 120 days from the date of judgment. But what happens in the meantime and in between time is an actual trial that we're about to have right now. So that is the due process that the Constitution affords, because if it's found not guilty, then your moped gets put back to you. There is no cost assessed to you. The city will pay any cost for impoundment and fees. Why? Because you're found not guilty. So the fact that you're stating that you're not getting due process, well, we're about to start the due process, which is the trial. So for those reasons, your motion is denied. Now, you can put that in the file. Put that here. Denied. For reasons stated on the record. Right. Now, with regard to one other supplemental thing. So the civil infractions that are in here, the no proof of insurance and the defective tires, those both stem from the same incident occurrence?
That's correct, Your Honor.
And are we setting these for a formal hearing? Are we having these as a formal hearing now with regard to these as well?
However the court wants to proceed. I mean, if we have a jury, we've got a jury. I mean, we can
Because the jury doesn't do these.
Right. I mean,
so
if you want to do
because what I'm saying is I have no problem if you're going to put in evidence and it's going to be the same witness and I got everybody here. I will make a ruling on these after and outside of the jury's decision-making and vision, so they're not
Yes.
gonna see that, so they won't be influenced in any way by it as to, well, the judge said he's already responsible for those, he's probably guilty. They won't hear anything from that. I'm just saying I'll make that a separate ruling on this, but we're gonna have the formal hearing with regard to these, because I think having a trial and this is about as formal as you can get. So, but all of the decisions and everything about these will be outside of the jury's presence, because I don't want to taint the jury to think that, you know, oh, well, the judge said he's guilty of the other things, so he's probably guilty of this. They're not gonna hear any of that. Just put it in your evidence and I'll make sure of it afterwards.
Okay, fine, that's what, we'll just address it during
Yeah,
the
that's
correction
gonna be
process.
part of
That's fine.
the. And Mr. Martin, with regard to that, you'll be able to cross-examine about anything like, you know, the tires, they won't understand what it has anything to do about anything, because I'm not gonna instruct them that they're even thinking about that. I'm the one who'll make the decision on that, because these aren't jury trial things, it's just civil infractions. So, and that way, they're not gonna get into it or about anything or hear anything about it really, other than they're gonna hear the evidence for everything. I need to hear the evidence about this. So if you have any cross-examination with regard to defective tires, if you have any cross-examination with proof of insurance, you know, I don't know, maybe it was on your phone, maybe it was in your pocket, or I don't know. I don't want to put it, I'm just saying, you can ask about all those things and make sure you're doing that, because we are having the formal hearing on these as well. So they won't understand that it has anything to do with their stuff. I'll make that determination after they're gone. So that way it doesn't change their viewpoint of view, okay? So,
We're clear, Your Honor.
okay, very good. So let's go ahead and,
Before we go
any
into-
other supplemental matters?
I think there was one outstanding motion that at our last pretrial hearing, Mr. Martin attempted to address with the court. I believe it was filed. I see a motion with an October 25th date. Is this the same argument?
October 25th.
Your Honor, it's a motion titled, motion for demand to dismiss, discharge these cases based on the attached legal arguments titled nobility. I don't know if the people were served a copy of this pro se motion. I did get a copy from your court staff.
Okay.
Let me converse real briefly with my client to make sure he wants to move forward with this argument. Okay, my apologies, Your Honor. He is ready to move forward with this argument.
All right, so the only other outstanding motion, and then the last time we were here, I said on the day of the trial that we'll clear up any outstanding motions that had not been heard. The only last motion, and obviously you filed a new one this morning that you brought with you, and we heard that, we discussed that. So you have this other motion for demand to dismiss and discharge these cases based on the attached legal arguments of title of nobility. So, give me 1 second too, because I don't know if it's, did you have attachments to that? Because I see you got your handwritten.
So
You got your hand, what I was saying, I have your loose leaf handwritten motion like I see on your normal motions. But then I see like some pages that are, I don't know, it says page 49 of 88. So there's not 88 pages to your motion. is
That was
there?
in the mayor should have crossed the page. I would have been a little more professional, I guess, but you know, let's.
No, I'm not-
Yeah,
I'm
I'll
not-
tell you how many pages there should be here.
I'm not speaking to your professionalism. I just want to make sure that I'm not missing the other 88 pages. That's all.
Yeah, that's on the page now. 5, 6, 7, 8. I'm counting 8 here. 8 in addition to the motion of the actual legal argument. You know what I mean? That's what
Okay, so I got 4 pages of, I got 4 photocopied pages and then 2 handwritten. So 6?
Motion to dismiss.
6, you have 6 total pages.
6 total pages?
Hold on, I think you should have 8. Let me see.
One of the pages that's in our possession is a blank page that's looks to be a photocopy of a hand, just loosely notebook.
Let
paper.
the record reflect. I'll just go through what the court has. You tell me if I'm missing something, okay? So I have dated October 25th. This seems to be your title page, where it says regarding City of Taylor versus Eric Martin. And it says sincerely Eric Martin in red. This is your opening first page. And then I have the motion heading page based on the attached law that is in demand. It is demanded that to take judicial notice of, okay? And so that's the 2 front pages. Then I
There should
have
be 8
page,
pages of a legal argument. I just counted 8 more pages on each there.
well, there's 2 handwritten. And then there's 1, 2, so I have page 49 of 88,
Right.
page 51 of 88,
That should cross out maybe, there's maybe
Page
more
53 of 88.
number of the pages
I know,
coincide.
well, that way, they're numbered, but I just want to make sure these are the numbers that I'm supposed to have. 49 of 88, 51 of 88,
Wait, where's 50? 40, where did it go?
53 of 88, and 55 of 88.
Oh,
Those
you
are
went
the
from
ones I had.
49 to 51, this is skipping the page.
I don't
49,
know, I
50
didn't
up to-
file it, I didn't give it to myself. That's
Right,
all I
so you
have.
should have 49, hold on, let me look at it, let me see.
So
You have 49, 50, 51, 52.
I have a working theory on this, Your Honor.
I don't have 50.
I have pages that have a court stamp every other page. My suspicion is this was double-sided. Did you write that? Were these printed double-sided?
No, I didn't send them double-sided, so.
Okay.
May I approach the judge with this?
Sure,
copy
if you
that
could
has,
just take page 50, because I don't have 50, I don't have 52.
Your Honor, let the record reflect I'm approaching with the entire motion. Mr. Greco. you have to go.
Judge, just looking from here, it looks like yours are double-sided.
Oh. Yeah, see, mine are double-sided, okay,
Yeah.
hang on a second now.
Okay,
Yeah.
so that's what
All
I'm trying
right.
to get us into it. Here's your motion.
All right, so yeah, I got 50 on the back, so I guess you did print it double-sided or something, or?
Sorry for the interruption. It just sort of looked
No,
like that's what
good-
happened.
Good call, good pickup, but the record reflected that also violates the Michigan court rules with regard to pleadings, but in an improper state, I'll go ahead and take it in the light most favorable to the improper defendant. So, all right, so Mr. Greco, do you have a copy of this motion?
I do.
Okay, you do. All right, so, Mr. Martin, go ahead with your motion.
Yeah, so with this motion, some of basically what's already said in here is, the driver's license. Okay, the U.S. Constitution started with Article 1, Section 10, the state's prohibited from granting titles of nobility. The driver's license is a title of nobility, it's a special privileges for so-called drivers, and it's prohibited.
Okay, so do drivers get the nomenclature of king, duke, duchess, governor, but what specific nobility titles are given to people who are drivers?
As it says in here, like I put in here, it's a privilege granted to a certain, right here, a title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8A, page 40, a driver's license is a privilege which is granted by the state as a corporation.
Sir, I am going to ask that you not mumble. You're going to have to speak up because it's hard to hear. I can barely hear you, and I know that Ms. Hancock is going to have a hard time trying to make a record of this.
Yep, this, the title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8A, page 40. A driver's license is a privilege which is granted by the state. Well, there's a lot of argument to say here, but basically sum up, like I said, the driver's license title of nobility, it's a special privileges granted to so-called drivers, a certain select group of people, and U.S. Constitution, Article 1, Section 10 prohibits the state from granting titles of nobility.
Mr. Greco?
Yes, very briefly, Your Honor. The argument that he's asserting with regard to this applicability to driver's licenses has no applicability whatsoever. As the court is aware, being a constitutional historian and an American, that the titles of nobility was a big deal at the time of the founding of our country with respect to nobility titles such as that you described as king, duke, things that would be granted to somebody just by either right or granted certain rights by that title that have no application whatsoever to a state issuing a driver's license for those that are able to obtain one in the state. It has no applicability whatsoever.
So I will note that the Oxford Dictionary defines nobility as the quality of being noble in character. That's one. Two, the quality of belonging to the aristocracy. aristocracy. So, like Mr. Greco said, that's like you're a monarchy or whatever your setup is, like in England, that kind of thing, Duke, Duchess, all that good stuff. So, contrary to Roger Miller and the fact that is anybody who's the king of the road, it's not true. There is no nobility that comes along with driver's license. When they use privilege to talk about privilege, that is in opposed to a right. You can either have something that's a right, or you can have something that's a privilege. And a privilege is something that can be regulated for the safety, health, safety, and welfare of all citizens. Like I said, you keep talking about a right to travel, you got a right to travel. You know what? You can walk anywhere you want to. But if you're going to use something that can hurt somebody else, that needs to be regulated, such as a plane. You can't just go and buy your own helicopter. Just, you know what? I'm tired of all the traffic jams. I'm just going to fly my helicopter from my backyard, land it on top of the courthouse, and then I'm going to just, park here. You know what? You can't do that without a pilot's license. Why? Because you could literally kill people, like if you fall out of the sky. So there's a reason cars can kill people. It's no different than why you have to have a permit for certain weapons. We have a right to, and that's the clear right to keep and bear arms. But you still have to have certain weapons. You have to have a permit for those things. And, so there's regulations that go along with that for the health, safety, and welfare. And giving a driver's license is because we want to make sure, the state wants to make sure that anybody who's driving has the basic knowledge and understanding of what it takes to drive safely, so that it's going to be for everybody, for everybody's benefit. So with regard to the violation, there's been no deprivation of your constitutional rights, and there's been no violation of the Constitution. And the fact that you need to have a driver's license is something that has been ruled upon by the Michigan Supreme Court, by the United States Supreme Court, and the right to travel does not supersede your ability to need a driver's license. You can travel all you want to, like I said once before. You can walk yourself all the way from good Forrest Gump from here to across the country and all the way back. But you got to do it by walking, maybe even riding a bike or something that doesn't require a license. But for licenses, certain things need licenses. There's a reason for it. And all of those have been hundreds of cases that say, yeah. So for those reasons, your motion is denied. So now let's begin by bringing in the jury.
Can I object to that? I'd like to respond to something that you.
There's nothing to respond to. I've made my motion. I made my ruling on your motion, and your motion is denied. If you want to appeal it, you can appeal it to the circuit court, but that's between, all right, so.
That will be
right
going
now,
actually.
we're getting to the.
All the verses, we won't provide notice that the court will be appealing all the issues that's
Duly noted.
diverse and
Duly
deny my
noted.
emotions and demands based on the Constitution.
Duly noted. All right, so I have,
I was big once. Back in the 80s, I was bigger than big.
Yeah, I know.
Bigger than shares. There's implants.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so the next time I premiere a video, you can be in a live chat with everyone else and leave a comment in the comment section. Tell them what you think. And a huge thank you to all of our Facts or Frauds channel members. And if you're still hanging out, thank you. I appreciate you all. Make sure you hit that thumbs up button, you're subscribed, and leave a comment in the comment section telling me what you think. Until next time, I'll see you soon.